Good afternoon. Since YouTube is obsessed with copyright law now, I'm going to read it to you. The Copyright Act. Put simply, the Copyright Act 1994 is a set of guidelines that explains how published content can and cannot be used. The general rule is, if it is published, it is copyright protected. The Copyright Act kicks in the moment you wish to copy, scan, save, or share published material as an honest, law-abiding citizen. The important thing to know is how the law applies to you. Copyright notice. This is a good place to start. The notice is often on the inside front cover. Hard copies are in the terms and conditions. If material is sourced online, if you wish to copy, save, or share outside of what is permitted on the notice or by law, you need to ask permission first. General copying printed material. You can copy without permission from an original if it is for research, private study, criticism or review, reporting current events. The amount copied should be deemed fair. For example, it might be fair for an individual to copy an entire poem or article if it is relevant to their study topic. On the other hand, it is unlikely to be fair to copy an entire book if only a selection relates to the study. Education printed material. Teachers are permitted to copy the following from an original hard copy. A single copy for lesson planning purposes, multiple copies for up to 3% or 3 pages, whichever is greater. The section copied must not give away specific information, i.e. chapter summaries. The Copyright Council website has useful information on using copyrighted material for download here. If you have a specific copyright question, talk to us. So I'm going to see if I can download it. What that gives me. Now, what I keep telling YouTube is I'm doing mine for educational purposes. I'm teaching people how to sing with their favorite artist. That is not against copyright material. Now, I can't use the whole album, for instance, to teach you how to sing like Queen. But I can use one song from Queen to teach you how to sing like Queen. Yes? Now, if I can use one song, I can use up to a certain number of popular songs that I hear on the radio to a point too, to teach you how to sound like Freddie Mercury. There's no law that says I can't do that. And if I'm critiquing Freddie's live performance and his studio performance, I can do that too. And teach you the difference between sounding similar to Freddie and impersonating too. Right? It's all for what? Information and education. There's no way YouTube can say I am not doing it for educational purposes. At all, YouTube. Now, the one I want to look at, though, is copyright for sound recording. Okay. This is copyright for sound recordings. Copyright for owners of sound recording. The Copyright Council of New Zealand, for example, does not provide legal advice. The purpose of this information is to give introductory information only. If you need to know how the law applies to your particular situation, please seek legal advice. Sound recordings are automatically protected by the Copyright Act of 1994, which provides the owner of sound recordings certain rights in relation to their work. The sound recording attracts copyright regardless of the medium in which the recording was made or the method that the sound was reproduced. For instance, a sound recording could be in form of a vinyl album, physical CD, digital download, MP3, streaming service, and more. There is no requirement to register the sound recording or to go through any formal process for it to be protected by copyright. Owners of copyright in sound recording. The owners of copyright in sound recording is often a recorded label or an independent artist. Whoever produced and owns the original master sounding recording is your collaborator. If you collaborate with others to make a sound recording where ownership is not clear, it is sensible to agree in writing about copyright ownership, as it helps avoid confusion and disputes in the future. Separate copyright in music and lyrics. Music and lyrics contained in the recording are also protected by copyright. Copyright in the musical work, and lyrics. Literary work are separate and additional to any copyright in the sound recording. For example, in a CD, there may be separate copyrights in each musical composition, lyrics to each song, and sound recording of the music and lyrics. Rights as a copyright owner. A Copyright Act gives the owner a copyright in the sound recording the exclusive right to make copies or reproduce their work, issue copies of the recording to the public, play their recording in public, communicate their recording to the public, for instance by broadcasting or webcasting their work on the internet. The copyright owner can authorize another person to organization to do any of these activities. This is usually done through a music license operation, which collectively licenses these rights on behalf of large groups or copyright owners. In New Zealand, these rights for sound recording owners are administered by Recording Music NZ. How long does copyright last? In New Zealand, copyright in a sound recording expires 50 years from the end of the calendar year in which the sound recording was made, or was legitimately made available to the public, whichever is the latter. Because there is also copyright in the music work, the expiry dates of the copyright in the music and lyrics might be at a different time to the sound recording. In fact, if the music was composed and the lyrics were written at different times, these two copyright terms may also be different. Sometimes remastered recordings which will result in a new copyright, the term of which will run again. The period of copyright protection is longer in Australia, Europe, and the United States, generally 70 years from the date the sounding recording was made. Dealing with rights in copyright work. As a copyright owner, you can choose to administer your rights directly, or you can assign or license your copyright to another person. Assignment. If you assign copyright in a work, you are selling or transferring it to someone else, and that other person becomes the owner of the copyright. An assignment of copyright must be in writing and signed by the person assigning the copyright. License. License means that you remain the owner of the copyright, but permit someone else to deal with it. For example, allowing recorded music NZ to manage broadcast and public performance rights. You can limit the rights granted, for example, by type of use, by period of time, or by territory, and impose conditions, for example, that a person cannot use the work until you receive payment. Copyright can also be transmitted to others on the death of the copyright owner. When copyright is infringed. Copyright is infringed in sound recordings when another person does something in relation to the work in a way that is reserved to the copyright owner without permission. Infringement may occur in retaliation to a whole work of substantial parts of work. The playing of a sound recording in public is a restricted act, and therefore the permission of the copyright owner is required, and also copying a sound recording is a restricted act under the Copyright Act. There are a few special circumstances in the Act where a person may copy a sound recording without permission. These include a fair dealing for the purpose of criticism, review, or news reporting. Right. A fair dealing for the purposes of research or private study, certain educational purposes for personal use. Yes? For further information, see our information sheet, Fair Dealings, Copyright Use in the Education Sector, and Personal Use, Copyright, Format, and Time. Shifting. There are limited situations when playing of a sound recording is not infringed of copyright. If is not an infringement of the copyright in the sound recording to play the sound recording as part of the activity or the benefit of a club, society, or other organizations. If the following conditions, i.e., all and not just one, are compiled with the club, society, or organization is nonprofit, which I'm part of it, running my own ministry in church, and I'm nonprofit, right? And that the main object of the club, society, or organizations are charitable or are otherwise concerned with the advancement of religion, education, or social welfare, which I am. I know. And that the proceeds of any charge for admission are applied solely for the purpose of the club, society, or organization. Organizations such as sport clubs and working men's clubs have been found to fall outside this limited exemption. But I'm running a church, please. That's nonprofit. Now, as a church musical leader, I'm teaching you how I learned to sing both secular and church music too. Again, understand that. I'm teaching you all forms of music without judging you, since Jesus said, "Judge not, lest ye be judged." Do you understand, right? Now, if you don't want to hear that, YouTube, you're breaking the law, not me. Bye.